welcome you to the second of a series of distinguished programs at New York Law School to celebrate the Constitution's Bicentennial.
John McGinnis.
John, good. Come up here.
Apologize. Although I'm a native New Yorker, I did not reckon with the traffic. We got 16 blocks in 16 minutes.
I was just welcoming everybody to this second of three programs. I think the Senate's Judiciary Committee's hearings on Judge Bork have served as a reaffirmation of our commitment to constitutional law, and the subject of evolving concepts of privacy has been very much in the forefront of the discussion. Could not be more timely, therefore, for our panel discussion today on this critical subject. We are fortunate to have such a panel of distinguished scholars to discuss concepts of privacy. And we are equally fortunate to have as our moderator the Honorable Roger J. Minor, member of the U.S. Court of Appeals, Second Circuit. Judge Minor was an honors graduate of New York Law School, where he served as the first managing editor of the school's law review. He's also awarded the Nathaniel Goldstein Medal on Constitutional Law and the Law Forum Prize for his contribution to the law review. After graduation, Judge Minor practiced law privately in his hometown of Hudson, New York, with his father, also an alumnus of New York Law School. Later, he entered the public sector, first as Hudson City Attorney, later as District Attorney of Columbia County, then as one of the state's youngest state Supreme Court justices. In 1981, Judge Minor was appointed U.S. District Judge for the Northern District of New York, and 4 years later to his present position on the U.S. Court of Appeals, Second Circuit. I'm pleased and honored to present Judge Minor, who will introduce the panelists and lead the discussion.
Welcome to our panel discussion on evolving constitutional concepts of privacy. This program is one in a series sponsored by New York Law School in celebration of the Bicentennial of the United States Constitution. It seems quite fitting that this particular symposium be convened at New York Law School, because the most distinguished alumnus of the school, Supreme Court Justice John Marshall Harlan, was an important contributor to the evolution of a concept of privacy embraced in the liberty aspect of the due process clause. According to one treatise, the right to privacy was given its first exposition by Justice Harlan in his dissent in Poe against Oman. In that case, which preceded Griswold against Connecticut by 4 years, and involved the same Connecticut contraceptive statute challenged in Griswold, Harlan's dissent included these words: "I think the sweep of the court's decisions under both the 4th and 14th Amendments amply show that the Constitution protects the privacy of the home against all unreasonable intrusions of whatever character." The Poe case is not referred to often because the majority found no justiciable issue in view of the fact that there had been only one prosecution under the Connecticut statute during the preceding 75 years. It was not until later that somebody got himself arrested and the court was constrained to meet the issue head-on in Griswold. Justice Douglas there wrote of emanations and penumbras for the majority. Justice Harlan, concurring, adhered to the position he had staked out in the earlier case. Justice Goldberg danced around the 9th Amendment. There were other opinions, concurring and dissenting, and history was made. So much for the New York Law School connection. And it is our purpose to examine, in the course of this discussion, the nature, origins, validity, and prospects for future development of the constitutional right of privacy. To that end, there will be an interchange among the panel members and myself for an hour or so, and I shall then open the discussion to questions and comments from the floor. We anticipate a lively debate all around, and now it is my pleasure to introduce the members of the panel. To my immediate right, John O. McGinnis is a Deputy Assistant Attorney General of the United States in the Justice Department's Office of Legal Counsel. He is a graduate of Harvard Law School, where he was a member of the Law Review. He served as a clerk to Judge Kenneth Starr of the United States Court of Appeals for the District of Columbia Circuit, the second most important circuit in the nation. He was an associate at Sullivan & Cromwell and an attorney advisor in the Justice Department before his promotion to his present position. At my far left, down on this end, is David Chang, a colleague on the New York Law School faculty, where he serves as associate professor. He is a graduate of Yale Law School and was an assistant in instruction there. He served as a law clerk in the United States District Judge W. Arthur Garrity in the District of Massachusetts. He teaches constitutional law here and has published in several areas, including racial discrimination and equal opportunity. At my far right, Norman Dorson is Stokes Professor of Law at New York University Law School, where he has been a faculty member since 1961. He is a graduate of Harvard Law School and was an editor of its Law Review. He served as a clerk in the chambers of Justice Harlan in the Supreme Court and has himself argued several landmark cases there. He is the author of a number of books and articles on constitutional law and civil liberties, and since 1976 he has been president of the American Civil Liberties Union. Currently he is a star of stage, screen, and television in connection with the proceedings going on in Washington. He also is known for the fact that he's a member of the Second Circuit Historical Committee, his most important credit. And to my immediate left, Harlan L. Dalton has been a member of the faculty of the Yale Law School since 1981. He is a 1973 graduate of Yale Law School. Following graduation, he served as a law clerk in the Southern District here, the United States District Judge Robert L. Carter. He was a staff attorney at the Legal Action Center in New York from 1974 to 1979, and assistant to the Solicitor General of the United States, 1979 to 1981. He's a member of the editorial board of the Journal of Legal Education. Today we have available his book, AIDS and the Law, just published, a guide for the public, edited by Professor Dalton, available in your bookstores everywhere. Without further ado, we turn to our interesting, provocative, and controversial topic, evolving constitutional concepts of privacy. I would like to start out by defining our terms, so I open the discussion by posing a question which I ask each member of the panel to answer. The question is, what do you understand the phrase constitutional right of privacy to mean? Professor Dalton, we start out, I'm sorry, I told you I would start out with Dorson, so I will. He's all ready for this. All right, out of respect for his age and seniority. Norman, what is your definition of right?
Now, if I were Judge Bork, I'd say this whole panel is a waste of time because there's no such thing as a right of privacy. But in fact, there are several rights of privacy and not one. The one that's gotten the most attention in the last few years is the right of sexual privacy, and I assume that's what we'll speak about mostly. But there are many other types of privacy. The privacy that protects people against unreasonable searches and seizures, whether by human agents or by electronic means. The privacy that protects people against the unauthorized use of their name or picture or portrait in order to capitalize on a commercial basis. There's the right of privacy that relates to the unauthorized dissemination or disclosure of information that an individual wants to keep secret, Each of those is a separate strand of the right of privacy. Each one has spawned cases, although only the sexual privacy issue has led to a series of cases in the Supreme Court. I suppose the wiretapping and search and seizure ones also. So those are, in very summary terms, the different types of rights of privacy. And of course, lately there's been a lot of controversy over whether the right of sexual privacy should extend to the right of a woman to choose whether or not to have an abortion, or the right of homosexuals, or for that matter, heterosexuals, to engage in sodomy. And I'm sure we'll get into those issues as we proceed.
All right. Professor Chang, your definition.
I really can't give a definition without leaving most of the questions that we'll probably be discussing. I can define the problem of privacy. The conflict about which this purported constitutional right of privacy is all about. On the one hand, we have an expressed concern for individual autonomy, individual happiness, the value that seems to motivate much of the privacy decisions, constitutional privacy decisions. And I am speaking of sexual privacy, Griswold wrote part of it. And that sounds very good. Pursuit of happiness is a dear tradition in this country. The problem, however, is that we're different. And not only do we pursue happiness in different ways, we pursue happiness in conflicting ways. The question is how that conflict that necessarily arises when people pursue happiness as they see fit should be resolved. One way to do that is to ask each individual, how should the conflict be resolved? Do it from the individual's perspective. And that doesn't help much. It just restates the problem. An alternative approach, or a category that encompasses many alternative approaches, is to define which pursuits of happiness should be protected by reference to external decision-making, some sort of social decision-making. And in this constitutional system, there are basically three political forms in which these decisions can be made. That is, which pursuits of happiness should be protected, and that is the states, Congress, or the Constitution itself. To me, the problem of constitutional privacy is to determine in which form the Constitution allocates authority for resolving these sorts of conflicts. It's fairly clear that when we're talking about wiretapping and that sort of criminal procedure searches, the Constitution makes policy in the Constitution itself. When we're talking about rights to reputation, we seem to be, at least so far, talking about rights that are functions of state law. The disagreement now, as a matter of constitutional law, is whether the Constitution itself makes policy about issues of sexual privacy.
All right. Thank you. Welcome. You're ready now.
Two seconds after I yield to the floor. I think it's traditional to divide the right of privacy into two categories. And I will use a mistake that indicate what they are, but I'm not sure the tradition is all that eliminated. When I say traditional, I mean traditional in the 1970s and 80s. Things changed radically. The two categories being essentially sort of guarded rights of privacy, the right to keep private, secret, that one chooses to. And secondly, the right to personal autonomy, that is the right to David Maxwell once we have. There's another formulation attributed to Justice Black, which is the right to be let alone. And I rather like that formulation. But I'd like to add a couple of other notions, which are really my attempt to spin out the notion of autonomy. One is the right to decide for oneself, and the other is the right to be true to oneself. And I think it's those notions of privacy that are most involved in we have to understand that we are all different. And I think David has put his finger on one of the central difficulties in evolving any constitutional right, other than ones that are explicitly set out in the Constitution, and even those that are outside the line. The difficulty is that we assume that liberty is something that we hold in common, and yet insofar as we are different, the very notion of having a community of interest is incompatible with protecting individual variation on those interests. And so I think that's what really gives the right to privacy its bite. That is, it cannot simply be that we all have in common some common notion of privacy, but because we are all different, the right to privacy also means that each of us must be guaranteed the autonomy to decide for ourselves and to be true to ourselves.
Yes.
I think our topic, I will confine myself to the topic of sexual privacy. And right away, I want to begin by saying that in my view, the term privacy here is really a little more than a term of propaganda, because the right we are discussing here tonight has really nothing to do, or little to do, with the term privacy in the vernacular, or of the right to privacy as it was understood at common law. It is the right to engage in certain forms of sexual conduct and certain other forms of activities which the courts have declared to be fundamental. And like most terms of this sort, the term has been chosen because it's a term that everyone sympathizes with in the common understanding. Everyone likes his privacy. Of course, in the law, however, privacy may be a necessary, but can never be a sufficient activity for sufficient condition for an activity to receive constitutional protection. Price fixing in private, contracting at below the minimum wage in private, and axe murder in private are not simply legal because they are done in private. Nor does it have anything to do with the right to privacy, that right that was celebratedly understood in Warren and Brandeis's article, path-breaking article in the Harvard Law Review, where that interest is the interest of protection from unwarranted public comment or exploitation. As some of our presidential candidates have seen, that right to privacy may in fact be now an unconstitutional right. It may in fact abridge certain rights under the First Amendment, at least the greatest expanse of that. So what are we talking about here if we're really not talking about something, I think, that is comprehended by the common term of privacy? I think the first candidate for something we're talking about is a right of autonomy, or I'd say call it a classical liberal principle, the kind that was familiar, popularized by George Stuart Mill. This way, one would have a privacy right to do X so long as X does not harm anyone else who hasn't consented to participate in the activity one is engaged in. This classical liberal principle, though, I do not think captures the understanding of the right to privacy today, because it is both far too broad and too narrow. First, the right of privacy, at least as it's developed, does not apply to certain kinds of conduct, homosexual conduct, that really can't be distinguished from certain other kinds of conduct the court has protected in terms of harm to people who haven't consented to the activity. More broadly, it can't be distinguished from other kinds of complete activities that have nothing to do with sex, but which are activities that have something to do with human autonomy and would come under the rubric of our classical liberal principle. Most notably, of course, this would be the right to contract, in whatever ways you wanted, with whomever would consent to contract with you at that wage. And I haven't noticed that the Supreme Court has been reviving that principle of late under the rubric of the right to privacy. And finally, it's also too narrow, because, at least in the case of abortion, the Supreme Court talks about someone having a right to privacy even when it affects someone who hasn't consented to having the activity under discussion for him or her to participate in, to put it mildly. So I think we see that principle as both too narrow and too broad. And what are we to do then to define it? I think the way I understand it is as a revival of simply a cluster of natural rights. It's odd to call it that, as I think I'll suggest, but it really is, I think this is what the Supreme Court has been doing. It's defined some activities as so fundamental to our definition of the self that they are equivalent to what natural right theorists thought of as natural rights. Of course, it is the fact that many of these natural rights are to natural right theorists precisely what would be unnatural. But that is one of the conundrums of creating a right that seems to draw on the kind of cluster of concepts that are defined by some imminent principles of morality. Because unlike the period in Ogden v. Sanders, where Justice Marshall could talk about the right of contract and distinguishing this from the liberal principle because he was operating under, there was a natural right to contract, and he drew upon this from the nature of society and clearly thought it was some kind of objective truth. I don't believe this is the way we think of rights nowadays. And so, alas, I find it difficult to give any unifying theme to the right of privacy, other than to say that a right to privacy is something about a person's self-definition that 5 justices of the Supreme Court think should be fundamental.
Now that we've all agreed on a definition of the constitutional right of privacy, we can push on. Actually, when Professor Thorson started out, he spoke of some of the traditional concepts of privacy, such as the right to use a picture and portrait, some of the that's a statutory New York provision on privacy. There are certainly court definitions of privacy, all the trespass questions of invasion of privacy. We'll restrict ourselves to the constitutional meaning, and of course, Norman, you have touched on search and seizure. There are other associational rights from which privacy obtains. What do you see as the constitutional sources?
Well, let me first say I was very interested in what Mr. McGinnis said. I was shocked by the last thing he said because he sounded just like the Harvard law professors who follow the philosophy of critical legal studies when he said that the right is whatever 5 justices of the Supreme Court say it is. And I hope that nobody else from the Justice Department is here
to subscribe to that.
To have heard him say that. Well, a few points. First of all, it's quite right to say that autonomy is an important aspect of the decisions that relate to sexual privacy. I quite agree with Mr. McGinnis, and I think my other panelists mentioned this, but I think one can't be too quick to say that privacy has nothing to do with cases like Bowers v. Hardwick, the homosexual sodomy case, because these 2 men were engaged in sexual activity in the privacy of their own home, or in their own home. And if that isn't privacy, if that doesn't have an element of privacy to it, the language and the meaning of words somehow escapes me. When people engage in sexual activity within their own home, to say that has nothing to do with privacy seems to me odd indeed. A second point is, Mr. McGinnis said, and I assume he's correct about this, or I'm not certain, but I think he's correct, that the common law privacy concepts did not cover some of the sexual privacy matters that we're dealing with primarily today. But think of 2 things. First of all, what is the nature of our Constitution? The very topic that we're debating today is the evolving Constitution. There's no rule of constitutional law. In fact, the rule is quite to the contrary, that only things that were fixed at the time of the common law are protected by the Constitution. There are all kinds of examples under the First Amendment, under the Fifth Amendment, and other constitutional provisions where as life unfolds in this country, and justices of the Supreme Court and scholars and lawyers and people live their lives and decisions are rendered, the Constitution changes. Now finally, this may be another way in which one can distinguish what I regard as true conservatism from a radicalism that masquerades as conservatism. Justice Harlan, who was the justice, as Judge Minor said, for whom I clerked, was a true conservative, and I disagreed with him on many matters, but he was a great man, and he had a clear vision of the Constitution. He wrote the strongest opinions that have ever been written to protect the privacy of people under the Constitution. He understood that it is conservative, not liberal, to protect the autonomy and the self-definition of people and the privacy of their homes. And that when some people who call themselves conservatives are willing to wipe out any constitutional protection for the most intimate relationships of human beings, they don't deserve the name conservative.
Of course, when you speak about the evolving Constitution and the changing Constitution, what a lot of people are concerned about was what guides judges when they tell us what the evolving Constitution means. Mr. Chang, your comment on that.
I suppose the question is whether constitutional privacy as it has developed has been an evolution or a mutation. Consider Griswold and free political forums that I mentioned earlier as possible bases for deciding issues of privacy. Griswold presented a very strange statute, one that seemed grossly out of step with prevailing morality. Not necessarily constitutional morality, but even everyday morality that finds reflection in legislation. It's possible that the statute challenged in Griswold wasn't even supported by a majority of the state of Connecticut. Indeed, before the Supreme Court ruled in Griswold, one house of the Connecticut legislature voted to repeal the statute. One theoretical grounds on which to overturn the statute in Griswold is that the majority of Connecticut no longer supports the statute. It's one possible source of privacy values, that is the state itself. If, however, the statute in Griswold was supported by a majority of the state of Connecticut, it seems rather clear that it was not supported by the morality of the national electorate. Indeed, it's quite possible that a national majority of Congress might have wanted to pass legislation prohibiting Connecticut's discretion from regulating marital privacy in this way. If so, we're still not talking about constitutional privacy. We're talking about legislative values held by a majority of the nation, perhaps enacted through Congress. Get to cases like Roe, however, or Harvard, it's less clear that a national legislative majority objects to the state policies that are challenged. And if so, one has to resort to a deeper or more fundamental source of values, and that is the Constitution itself. And that's where the problem is. So, of course, there would be a problem if the court struck down local statutes in the name of the sort of national morality that could be reflected in Congress. That could be a problem because it's anti-federalism, and also because it involves the court acting as a quasi-legislature. But let me remind you that this is not an unprecedented role for the court. The court plays such a role in the Dormant Commerce Clause, trying to determine Congress's balance of competing commercial interests and leaving it to Congress to reverse if the court misperceives the national balance. So I see three potential sources for deciding this sort of case. state, evaluating the national morality, evaluating the constitutional morality. Each source of striking it out on local statute has its problems. But each one along that line has more problems. Acting in the name of Connecticut's morality leaves, in theory, Connecticut free to tell the court that it was wrong. Acting in the name of the nation's legislative morality, in theory, and in practice under the Dormant Commerce Clause, leaves Congress free to tell the court that it was wrong. The difficult part of constitutional privacy is constitutional finality. And that's why ensuring that constitutional privacy is grounded in the constitutional values of the national electorate is so important.
You perceive that to be the court's role?
It is the court's role under the Dormant Commerce Clause. It is a less intrusive role than constitutional privacy as standardly understood. I'm not sure whether it is the court's role, but in cases like this, you tend to have statutes that are very old, under which litigation is infrequent, and under those circumstances, legislatures aren't left with much incentive to reconsider statutes on their own, or enacting as this quasi-legislature or in partnership with the legislature can't really serve that function.
Mr. Dalton, what do you see as the sources of the constitutional right to privacy in the Constitution?
Okay, I will answer that question. Let me, for one moment, apologize. I attributed to Justice Black the phrase, the right to be let alone. As soon as I did it, I knew that couldn't be right, if only because Justice Black, for reasons peculiar to his jurisprudence, would never recognize the right to privacy. Because he's concerned about exactly the questions that Judge Minor is asking, namely, how do you ground a right that's not explicitly mentioned in the Constitution? So he never recognized the right to privacy. I had the wisdom to defer to aid and send a note down to Norman Gorson asking where the phrase came from. And it's from Brandeis' opinion at Olmsted. Now, the question. I'm going to backward for just a moment and talk about the appearance in Washington and the testimony today of Barbara Jordan. I almost didn't make it here today because I wanted to be sure and hear what she had to say. And one of the things she talked about was how she testified, how her testimony was informed by many things, by a lot of study, by conversation, but most of all by being a black person for some 51 years, which I take to be her entire age. It's also informed by having been a politician in the state of Texas and having run for the state legislature in 1962 and again in 1964, having gotten 40,000 votes the first year, 64,000 the second year, and having lost each time because the state legislature of Texas was so malapportioned that to win from an urban area, one had to have many times the number of votes that one had to have from rural Texas. And along came a Supreme Court case, Baker against Carr, and then its progeny, which led to the one-person, one-vote rule. And as a consequence, Barbara Jordan was able to be elected to the back to Texas Senate and then the U.S. House of Representatives. She pointed out that Judge Bork, when asked about the one-person, one-vote rule, stated that he couldn't come up with a theory that explained the one-person, one-vote rule. And Barbara Jordan's response was, well, perhaps not, but it certainly is supported by common sense, it's supported by rationality, logic. Any person in the street can understand why one vote ought to be worth the same as another vote. And I tell that story by way of suggesting that too often I think it's important to come up with a global or meta theory to explain where a right comes from, what its limitations are, how a court should apply it. And my own feeling, my own understanding is that most rights, in fact, grow out of human experience and indeed our common experience. I talked about it briefly, echoes David's comment about the differences of people in American society, but we also have lots of similarities. And those similarities, I think, are in fact reflected in the Bill of Rights and other parts of the Constitution. Now, to come down to the ground and answer Judge Minor's question, I would suggest that, in a sense, one could say about the Bill of Rights itself, we almost didn't have a Bill of Rights because people were concerned, people meaning Madison and Jefferson, and Madison and Hamilton were concerned, that if certain rights were enumerated in a Bill of Rights, someone would come along and say, in Latin, inclusio unius,
Exclusio absurd.
thank you. That is to state that's to state certain rights, that is to exclude other rights. In other words, if we set out 10 and in fact there are 12 or 15, are we going to lose the other 5 because people are going to say, well, the 10 and the Constitution are the only rights that exist. It was for that reason that the Ninth Amendment was included, to make quite perfectly clear that we have other rights of constitutional import, rights recognized by the Constitution other than those in the Bill of Rights. So I would suggest that the warrant to the right of privacy is right there in the Ninth Amendment, not because it says privacy, but it says other rights. I think one of those other rights might well be the pursuit of happiness, which David mentioned, which appears in the Declaration of Independence, and which I would suggest is something that is a right that we all hold in common and hold dear. So I would suggest that history, culture, common sense, and the reservation rights in the Constitution are all sources of the right to privacy.
Mr. McGinnis, doesn't that frighten you? History, common sense, culture. How does the court find what the Ninth Amendment means? Does it look to the time of the adoption of the Ninth Amendment? Does it look to the time of the adoption of the 14th? How does the court go about identifying those rights that are not in the Constitution and that are reserved to the people? Or does the Ninth Amendment mean anything at all?
Well, I think it does mean something. I think, fortunately, it doesn't mean, even if the Ninth Amendment was understood to protect certain natural rights, which I don't believe it was, and I'll come to that in a moment, there would still be the great difficulty, as I alluded to at the end of my previous remarks, that in a world where we don't really look at natural rights in the way the Constitution did, perhaps the framers did, the difficulty would be that we wouldn't be grounded on some kind of clear principle of application, and it would be really a permission for the court to make up certain kinds of rights. And that's, of course, why I define the right of privacy as a right of autonomy to which 5 justices of the Supreme Court ascribe. It's not because I'm inheriting the School of Critical Legal Studies, far from it. It's because I fear that, of course, the critical legal studies school would be correct if a judge is just to decide what is good and has no law to apply. I agree that then the law is going to look very much like what the judges will protect, what are generally important to judges as a class. In the 1930s, rights of property were important. Today, in the words of one person who perhaps doesn't want this comment, like all the other comments that he's been reminded of in the last week brought back to him, he spoke of the gentrification of the Constitution, which I think is a very nice term, because it's not surprisingly that the class that becomes judges, certainly more and more the yuppification of the Constitution, the rights are going to look more like the rights of what urban, upper middle class people think are fundamental to our self-definition today. And so that's why we're so concerned about it. Now, I believe, therefore, that the problem of privacy is precisely the problem of how to ground it, of sexual privacy, to ground it in the Constitution. And I do not believe it can be so grounded. I don't believe it is very much like any of the other rights in the Constitution. It's not a procedural right, it's not a governmental structure right, it's not really simply a right to protect minorities, at least minority factions, in terms Madison understood it. It's not like the First Amendment, the right to protect the flourishing of the Republic, which is, I think, how the framers saw the First Amendment. So it's not even like those other rights, I would assert, with the possible exception of it may be most like the free exercise clause, that instead of having a free exercise of religion clause, you now have a free exercise of sexual practice clause. But just to state that proposition shows what a radical view of the Constitution that would really be. And finally, I'll answer Judge Minor's question as to what I think the Ninth Amendment means and why I think even if one decided to apply the Ninth Amendment, and I think there are these problems for the application of the Ninth Amendment, even if you agreed it meant what Mr. Paulson said, I believe that the difficulty with the Ninth Amendment is that it has quite a clear meaning, but it is not a meaning that is one that will make people who want a right of privacy against the states very happy, because I believe it means essentially that the federal government is a government of delegated powers, and that the enumeration of those powers is the guarantee that American people enjoy unenumerated rights against the federal government. I think it was quite rightly stated that this was added to the Bill of Rights because the framers were very concerned that by enumerating certain rights, particularly the federal, this was a federal argument that ran through the Federalists, that you would be construed to disparage certain rights. But all these rights were against the federal government. And the way the argument ran, according to the Federalists, was that, and indeed some of the anti-federalists as well, was that our protection against the federal government came from the enumeration of powers, because whatever you didn't give the federal government a power to do, you had a right with respect to the federal government against what it couldn't do to you. In other words, the framers thought of as rights and powers as a kind of dichotomy. And what they were concerned about is that by enumerating certain rights in the Bill of Rights, unless they had some principle of construction, which is what the Ninth Amendment, I believe, represents, that would be thought to mean that you wouldn't have certain rights against the federal government, by which one would mean that the federal government would have a certain degree of extra powers that were not enumerated. And this was the great fear at the time of the ratification of the Constitution and the Bill of Rights, of an encroaching federal government. There was very little fear at all of the state governments, except with respect to the few very discrete, almost entirely economically based clauses that were imposed upon the state governments in the body of the Constitution in Article 1, Section 9. So I think the prime difficulty for anyone who wants to generate a right of privacy is how that right can be grounded in an idea of law. And I would submit that an idea of law is an important conservative value, and those are true conservatives who seek to defend it.
How about the institution of marriage? Isn't that something that a conservative would seek to protect somehow? And can't you find something in the Constitution that would keep the police out of the bedroom to see whether contraception was being used? Don't you think there's something, even if you look at the First Amendment, the associational right, or perhaps even to the Fourth? I would want to get evidence like that. Forget about the 9th and the 14th and all of that. Can't you find something more specific in which to ground Griswold?
Well, sure. The Fourth Amendment, I think, it would be a substantial barrier to searching bedrooms, going and getting warrant. First of all, it's a substantial procedural barrier. Second of all, I think it would be difficult to come up with whatever the standard the Supreme Court has set in criminal laws, and I don't mean by any means an expert on that. And so that is certainly a barrier. It is a procedural barrier, not a substantive barrier. But I must say, I think the greatest barrier we have to wholesale invasions of the sacred marital precincts is the common sense of the American people. After all, most of these statutes we're talking about, the statute in Griswold, the statute actually in Bowers v. Hardwick, are statutes that, by and large, were statutes that came to the court through various kinds of test cases. I think Justice Powell, in footnote, suggested that there had been no contested case about the right of homosexual sodomy since 1939, or known to have been imprisoned for. Now, I'm not claiming that he is absolutely correct on that, but what I'm saying is that these statutes fall into dissuaditude because people have better things to do, and I do think that is the kind of common sense that one can rely on. What I don't believe we can do on is look at the Constitution for the judges to define what should be a fundamental right, because I think the American people have a better sense, unless we have some sense of objective morality sitting out there, of what really are rights that are fundamental to the American people.
So you're saying that judges have no common sense? Is that what you're saying?
Well,
all right.
The unspoken premise of Mr. McGinnis's remarks is that there are no constitutional rights unless they're explicitly stated in the Constitution. That is false. It's been false for a long time before Justice Douglas and before Justice Brennan were on the court. The right to travel is not stated in the Constitution. The freedom of association is not stated in the Constitution. Going back to the 1920s, the right to raise and bring up children, to send children to private or parochial schools, to teach children a foreign language, even though a state statute said you could not teach children in Nebraska a foreign language, a statute passed during World War I hysteria. All those rights were accepted by the Supreme Court.
Sterilization case.
That's right. Skinner and Oklahoma in 1942. But there's one very important point that is in one sense, a technical or semantic point, in another sense, something else. And that is, most of the decisions I've mentioned, in fact, none of the decisions I've mentioned, the 5 cases I've mentioned, travel, association, bringing up foreign language to children, sending children to school, and the sterilization case, were decided under a privacy theory. They were all decided under other provisions of the Constitution. The sterilization case was an equal protection case. The other cases were all liberty cases. 3 of the 4 were liberty cases, and freedom of association is a First Amendment case. Now, in one sense, that means that on a superficial basis, that would tend to support the proposition that Mr. McGinnis is making in his narrower claim that there's no right to privacy. But it does not support the proposition that there are no rights other than those stated in the Constitution. And what is the source? Let me read to you from Justice Harlan's opinion in Poe v. Ullman, the contraception case, in which he would have decided that case, not on the right of privacy theory, but on a liberty theory. The liberty of people to engage in certain types of intimate activity. What he said was that the way the 14th Amendment liberty right should be enforced is by balancing the demands of organized society and the recognition that this country was built upon postulates of respect for the liberty of the individual. And the court has had to strike that balance again and again in changing conditions. That tradition is a living thing. No formula could serve as a substitute in this area for judgment and restraint. And the question basically is whether we're going to be bound by a document passed 200 years ago without reading it, as Judge Minor correctly said, in a common sense way. And it seems to me that the decisions involving abortion, contraception, and if I may say so, homosexual activities are also intimately related to liberty in the true and what I would say is the most plain sense of what individual humanity is about, that the decisions of the Supreme Court that upheld that right are clearly correct, and that the Bowers v. Hardwick case, which will be reversed, I have no doubt, in due course, was clearly incorrect.
Well, let's talk about that. The Bowers case was probably the most recent expression of the Supreme Court on the question of the constitutional right of privacy, and bears most significantly on our discussion of evolving concepts of privacy. Of course, Justice Powell was the swing vote, and I can't quite understand his concurring opinion. He talks about the 8th Amendment. Did you ever understand that? He talks about cruel and inhuman. He said someday it might get to be cruel and inhuman people. But at any rate, that is the most recent discussion on the subject. And of course, Justice White writes for the majority although he was in the majority also in Griswold. But here he draws the line, and he finds that you're not talking about fundamental liberties when you're talking about sodomy statutes. And he says that these are not liberties deeply rooted in the nation's history and tradition, and in the conscience of the people, as was mentioned in another case. And so the question becomes, Bowers against Hardwick, where the court draws the line, or should draw the line. Professor Dorson says we haven't heard the last of the issue, and that a subsequent court will, in fact, come down in a different way. Professor Dalton, what do you say about that?
I think that if Bowers against Hardwick had involved a straight couple rather than a gay couple, Justice White would not have drawn the line where it did. It's a testament to the homophobia of Justice White, and I'm quite comfortable saying that publicly and openly. And I, for one, see no way of distinguishing the case of gay sodomy from the straight side. Mr. McGinnis a moment ago said that one of the difficulties with the right to privacy is it is not like a series of other rights, including not like the First Amendment right to promote the flourishing of the nation. I'm not real familiar with that First Amendment right, but it seems to me that the right to privacy is squarely parallel to the right to promote the flourishing of a nation. Namely, the point of the right to privacy, the point of ensuring people's right to be true to themselves, to decide for themselves about personal matters, is to promote the flourishing of individual human beings. And absent protection of the right of individual human beings to flourish, how can the nation flourish? Mr. McGinnis also indicated that Bowers against Hardwick was a test case, and that in fact is not true in terms of the facts of Bowers against Hardwick. Bowers, a police officer who had initially arrested Michael Hardwick for a different offense, and came by the house to serve a warrant on him, and a roommate to come by in and talk to him in the act. It was not a put up of Michael Hardwick. I assure you he was not anxious to have the police catch him in the act and engage in a sex. But even if there were a test case, that does not disparage the right to privacy in and of itself, nor does the fact that the sodomy statutes of Georgia or any other state are rarely enforced, if that's in fact the case, prove that they don't have an interorum effect. That is, they stand as a statement of society's morality with respect to individual behavior, both from the standpoint of society, and we can ask whether that's appropriate for society to enforce morals of the criminal law. But they also stand as a statement of society's morality with respect to persons who are on the other side of the law. That is, from Michael Hardwick and others like him. The very existence of the statute is a statement that he somehow stands outside the law, and seems to that has profoundly unsettling effect upon his psyche, whether he's ever arrested or not. Mr. gave us some time of us within the notion that Bowers against Hardwick involved activity that was indistinguishable from harm to people who have consented that we otherwise punish. I take it what that phrase means is that in many states that sodomy is a crime, or that rape is a crime. I guess it's something that people have consented. Since rape is a crime, therefore consensual sex can't be protected by the right to privacy. And I frankly do not understand that argument either. It seems to me that if that argument makes any sense, then it ought to apply equally to sex among straight people, which is to say that because rape, heterosexual rape is a crime, therefore heterosexual consented sex can't be protected by the right to privacy. And the logic of that honestly escapes me. One final point. I was a good boy for answering the questions, but I want to pick up some of the points that have been let fly so far during the conversation. Mr. McGinnis also suggested that the difficulty with thinking about the right of the Ninth Amendment as somehow reflecting the intention of the constitutional framework, at least the Bill of Rights framework, to assure future generations that there are rights other than those enumerated in the Constitution. So the difficulty with that is that the Ninth Amendment really stood as a reservoir of rights against the federal government rather than against the state government. And that's true. It's also true with the First Amendment, Second, Third, Fourth. But there also was a civil war, which resulted in, among other things, the 14th Amendment. But more fundamentally, the events that led up to the Civil War were evidence that states can be every bit as oppressive in our federal system as the
question always has been, are the courts, in general, the Supreme Court in particular, equipped to do that kind of line drawing? We're talking a lot about interpersonal, private, consensual behavior. And even if you want to go as far as you've gone, what do you do about things like adultery and incest and prostitution and things maybe that society decides should be outlawed, but involve strictly interpersonal, consensual, adult behavior? Who deals with that?
I'm quite capable of being consistent.
Who are the platonic guardians?
I do not create this difficulty for courts. Whoever created courts created this difficulty. It seems to me that this is no more of a difficult problem for courts than deciding what is the right to jury trial, whether civil or criminal.
That's a lot easier.
I am not sure. I sure wouldn't have guessed that one to have a constitutional jury of less than 12 and not unanimous. I certainly wouldn't have known, it's not obvious to me how one would apply the Seventh Amendment right to civil jury trial to cause of action that did not exist in common law. So some statutory created, some statutes passed in 1987. These are all difficult questions that involve where does Congress turn to in terms of grounding decision. They involve line drawing questions. That's what Congress courts. That's what courts do. That's what you do.
Yes, we have some guidelines. We always feel better when we have guidelines. Professor Chang, do you think that we should have some kind of guidelines? Of course, in your jurisprudence, you're looking for taking a sounding of how the country's going, I think, if I understand it correctly.
I don't adopt that jurisprudence as my own. I really suggest that it's an option. Indeed, I suggest that it represents a line of privacy analysis that's now important at the very beginning of this law. There are two very different approaches to constitutional privacy. One represented by Justice Douglas and picked up by Justice Black and Rowe and Hartley. The other, the minority concurring position of Harlan and Goldberg in Griswold, picked up by Justice White in his dissent in Rowe and his opinion in the court in Hartley. The two different traditions or approaches to constitutional privacy roughly replicate the distinction I made earlier between national values reflected through Congress or capable of being reflected through Congress, and national values that go beyond what Congress would choose, that reportedly are in the Constitution itself. I think Professor Dalton put his finger on the distinction when he said, I'm prepared to be consistent. I'm prepared to be consistent in how I draw the line. I will protect incest, and I'll protect prostitution, and I'll protect them all because it all relates similarly. It's all logically related to concern for individual autonomy and individual happiness. He's prepared to be consistent. Maybe I'm prepared to be consistent, but many people aren't. We all choose to draw lines, and that's the essential problem with this area of privacy and happiness is that we don't have to draw lines, arbitrary lines.
All right, Mr. McGinnis, just
Your Honor, this is my one text interruption, Judge. I'd love to. I could answer your question, but I'm going to give you some principles while I'm here. I want to make it happen.
send these to me. I'd like to.
I'm sure that McGinnis is going to filibuster out the rest of the session, so let me just dig it in. I would suggest, as a principle, that the state ought not to intervene in terms of criminal law when the sole basis for intervention is the majority's view of morality, or when there is a reasonable possibility that the majority's values are influenced by prejudice or bias. Now, if there's some other kind of harm that results from consensual behavior, that is harm other than to the sensitivities or the morality of the majority, then I'm prepared to. Those to me are maybe more difficult cases, where the only thing on the table is common morality or non-common morality, particularly where those moral questions or notions are possible
values have to bear some realistic relationship to national values. After all, constitutional values, constitutional provisions are politically created. Article 5 is the central guide, at least to me, in determining how constitutional meaning should be taken to law. Constitutional restrictions on local discretion, at least initially, by ratification, have to be endorsed and chosen by 3/4 of the states. A national majority. Now, you might ask, why should a national majority choose to pursue its policies by means of a constitutional mandate rather than by means of authorizing Congress to legislate? And that's a good question. To me, the answer, or a good answer, would be suggested by Hamilton's Federalist 78, and that is that when people choose to make national policy through constitutional mandate, they want to ensure that certain values are protected to a greater extent than Congress would otherwise choose, people themselves otherwise would choose to make a decision. The problem is with constitutional privacy is that we don't have the evidence that people are willing to have that sort of commitment to the value of individual happiness and autonomy in the context of sexual choices, whereas we do in the context of religion, speech, assuming the person has religion.
We'll assume that for the novice. Justice White talks about family, marriage, and procreation as representing those things protected by the right of privacy. He says that's where it stops. Homosexual activity is not included, so that's where he draws the line, at least homophobe or not. Mr. McGinnis, not too long. What's your comment about that?
Well, don't misunderstood my argument. Indeed, I was arguing not that homosexual conduct was somehow not incentive to conduct. In fact, I was just suggesting the Supreme Court in Bowers v. Hardwick rather had oddly given some kind of autonomy principle, not represented, not protected homosexual conduct. And I think that is very odd, and I find Bowers quite a troubling case in terms of the Supreme Court's previous jurisprudence, and I think there is an argument insofar as one can understand there could be any law in the privacy area that it was wrongly decided. And far from suggesting that homosexual conduct is somehow outside the pale or heterosexual conduct can be understood within a right of privacy, my point now is to suggest that when you get an area, when you have a rule of law that is as indeterminate as this, you really are risking the rule of law will develop simply by the judge's biases, because there won't be the rich theoretical underpinning of the rest of the constitutional rights under which judges decide cases. And so that's my main difficulty, and I'm deeply troubled by the Bowers case in terms of the right to privacy. I mean, I don't think there should be one, but as a lower court justice looking at that case, I think I would have been compelled to recognize such a right. Because unlike critical legal studies occurrence, I really do think that judges are bound by the law, and my whole point here is to try to confine the Supreme Court within the rule of law.
We certainly hope we can do that. I think now we'll just have each member of the panel kind of sum up his thoughts, and then we'll open the floor to some questions and comments from those of you who wish to fire some questions this way. Starting with Professor Dorsey.
Well, the only thing I'll say is that all of the members of the panel, one way or another, have suggested that in order for a right of privacy or a right of sexual autonomy to be recognized and to be valid, it has to rest on an acceptable and perceived principle. And the principle that would permit the Supreme Court and lower courts to act with fidelity is the principle that sexual activity by consenting adults cannot be criminalized. There is a principle of liberty. You call it autonomy, liberty, privacy, but it is true and it is valid and should be valid, and ultimately that will be the principle that will reign.
All right, that's well spoken. You expect the president of the ACLU to go that far out? My goodness. All consenting sexual activity.
By adults.
By adults, okay. He's always involved by adults. Of course, one of the things that bothers me is how does the government, and I'll go back to the original founders, how does the government legislate in these areas at all? Where do they get the authority? Before there was any Bill of Rights, and we discussed this earlier, that perhaps a lot of people argued against having a Bill of Rights because there were so many things that were taken for granted as being the rights of the people. Maybe we shouldn't have had a Bill of Rights, we'd have more rights without it. Mr. McGinnis, how about a summation from you?
Well, I guess I'd like to simply focus on the fact that even that principle wouldn't clearly protect, since Mr. Morrison just suggested, wouldn't really clearly protect the right to abortion, which is understood as the right to privacy. And that, I think, is the Roe v. Wade is obviously the most troubling of all the cases in the right to privacy. I think most of the other cases do not have as much effect in the body politic as Roe v. Wade, all taken together. And there, I think, we really see the great danger of a court operating without a rule of law on what it thinks of applying its common sense to an issue that no two philosophers, no two people who are widely read in the field could possibly agree on. And I think that is the real problem we face here. When we have hard moral questions that are not addressed by discrete clauses of the Constitution or by their fair implication, we are letting the Supreme Court simply become a court of platonic guardians that are going to make these moral choices that, for better or worse, in a democratic society, have to be made by the legislature.
The old text against non-text. President Golden, how about a summation?
Okay, just a couple of points. One, the fact that the right to privacy is indeterminate is partly a criticism. If the only law that courts should apply were that law was indeterminate, those of you who are students who just pay your tuition should get your degrees at the appropriate time because there'd be very little to learn here. Virtually all law is essentially indeterminate, more or less. The main point that I want to make, though, is to expand a little bit upon what Professor Dorson said. He indicated that we all agree that the right to privacy had to rest on an acceptable principle, and he offered one, which is fine by me. But I would like to suggest that it also has to rest upon the wellsprings of human experience. As Judge Myers pointed out, Justice White did agree that didn't have an acceptable principle of privacy coming into Powers v. Hardwick, and they backed off and drew the line. And the question is, at what point do people draw the line and why? And I think the truth is that in evolving, if we use evolving as a verb, evolving the right to privacy, one has to make over again in each case the reasons for having the right to privacy in the first place. That it's not enough to stand on the hitherto acceptable principle, but rather to remind the court that that principle is grounded in sound psychological reality, not simply logical. That the principle is there for a reason, that human beings, that the right to autonomy, the right to privacy is designed to foster human flourishing.
All right, President Chan, for our final summation.
Most of my comments have not addressed the substance of privacy, the content of privacy, and I will keep it that way. To me, the fundamental question is, so long as we're engaging in the enterprise of interpretation, so long as that's our goal, Constitution allocate authority to resolve these questions? And only secondly, how has that authority resolved this question? What evidence is there by the choices of the Frederick's ratifiers that these questions were left for state resolution or transferred for resolution by congressional type decision-making or congressional decision, or transferred to the courts to interpret constitutional decisions made in the form of mandates imposed on both national revenue and local revenue. We're dealing with questions of fundamental human political motivation when we talk about interpretation, as well as issues of what each of us might view as fundamental human rights.
All right, we can turn this podium around here. We can have somebody come up and speak into it. Anybody want to come forward? Yeah, can you turn that around, please?
Professors Dolphin and Dorson, do you limit your right of privacy to, well, you don't limit it, but is it unlimited? You mentioned sexual privacy, but would it extend, for example, to use of drugs privately?
The question
if
was,
not, why not?
the question is to what extent the privacy right goes beyond sexual privacy to drug use, for example. Well, we were limited, of course, to more or less the sexual privacy issue. We would extend it to a point where some other important value intrudes. And therefore, the ACLU, for example, believes that the right of privacy would extend to the use of marijuana. We have not taken it to the position of heroin because we thought there was an important health value that came up against it. Just to say a word about something Mr. McGinnis said, he's quite right, at least in part, that the principle I stated might not cover the abortion issue, but when I stated that there was a principle of privacy about consensual activity among adults, I wasn't saying that that was the only principle in the world. There's another principle, that a woman should have the right to decide whether to bear a child. That's also a principle, and that would cover the abortion issue.
I really feel good when I hear Professor Dorson. He has such confidence in judges, it's almost unbelievable.
We try to educate.
Yes, I guess that was also addressed to Professor Dorson.
Yeah, I'm going to answer that also. I think it's some of the more difficult questions that should be more obvious to me. The collateral consequences of drug use for society are rather more obvious to me than the collateral consequences of single sex. Nevertheless, I'm afraid I have to go somewhat farther than Professor Dorson. The notion that one might limit the right to privacy in terms of drug use because of a countervailing health consideration is to be quite mischievous. Indeed, I'm reminded of an organization called Dallas Doctors Against AIDS, who appeared in a lawsuit Baker against Wade, which was in which the Fifth Circuit decided about the same time as the lower court decision in Iowa case came down, and that's another deciding case. And there were a group of folks who were ultimately opposed to in favor of the side of the statute, but who then hit upon the idea of using AIDS, the AIDS epidemic, as a reason to favor side of the statute. That is, it's not simply the morality issue, but we're concerned about the spread of disease. It strikes me as a spurious argument, but it takes me to the point about health and drug use for health and sex is that I do believe in the autonomy of the individual and the right of people to make their own decisions about how to safeguard their own sex. So I certainly would draw the line, at least on that ground.
Would you draw the line between marijuana and heroin?
No.
No. Okay. We have to excuse Professor Dorson at this time, and we thank you very much for being with us. He's always a friendly, articulate man, and I always enjoy being with him, although I'm not sure that I agree with what he's trying to do right now. You're excused.
Okay. I'm sorry.
All right, take some more questions or comments. Yes.
I would address this question to Mr. McGinnis. First, do you believe that there is a fundamental human value concerning privacy? And if you do, how vital can the Constitution remain if it doesn't pertain to such a fundamental value?
Is there a fundamental human value of privacy, and how good can a Constitution be that doesn't recognize that? All right?
Well, I guess I think there is a fundamental value to certain kinds of privacy. Now, I think I assume your question was, do I think there are fundamental values for sexual autonomy? I certainly am skeptical. I believe that to some extent and not to other extent. It's very difficult for me to articulate exactly the line I would draw. Personally, I would probably draw it on the other side of Roe v. Wade. And that's why I very much am concerned about this free-floating right to privacy, because I think it doesn't capture the many difficult choices that necessarily must inform any understanding of what you call privacy, and I think we're talking about sexual autonomy. I think the Constitution leaves those kind of difficult choices that are questions, I believe, of degree, too wisely to legislatures. But if there are enough people who disagree with me, I think they should put in a constitutional amendment to the contrary.
I don't know if it's so free-flowing if you stop at Bowers, because certainly Justice White says that does include family, marriage, and procreation. That's about where he's willing to go, and at least that gives us some guidepost, some point for our compass for the future. Professor Compton, you had a question?
Well, is this working? Well, it's time to get up when Professor Thorson was there to use some of his ideas and testimony. But since he's going to choose Professor Thorson, who seems most close to the lines, and then anyone who chooses to comment on it. Professor Thorson pointed out that if these rights were not found or founded in the right of privacy by the court, many of them could be found under the right of liberty. Therefore, I would ask him, and I'll ask the rest of the panel, this question and pose this kind of problem. If we're talking about the right of privacy and the right of liberty, aren't they really part of the same conversation? In other words, if you have a liberty, then this should connotate a right of privacy in that regard. Therefore, I would think to restrict any concept that a right of privacy is guided or controlled by a moral majority or consensus or group in society, because liberty connotates the right to do what you perceive is right against the majority. Therefore, I think if you look at it that way, right of privacy need not and should not be considered as grounded in the majority consensus unless someone understands.
I agree with each and every word you said.
Thank you.
Well, I guess that takes care of that. I was going to ask you whether it was more like a trespass on the case.
Right.
Grounded in court.
It's curious if the Supreme Court had, in fact, gone the liberty of movement rather than privacy, but I think you're right with being somewhat clear that we're talking about a protection against the will of the majority in terms of protecting individual liberties. And so maybe some of the confusion would have been eliminated, and the word liberty at least appears in the Constitution, and it must be
looking to the source of choices that go beyond what Congress might make is essential in this area in which Constitution mandated sexual privacy is so hard to find as a matter of interpretation as opposed to a matter of what refers to policy.
All right, Mr. McGinnis, how about your 2 cents on that one?
Well, I must say, I disagree with that view, not surprisingly. And my difficulty with Mr. Dalton's view seems to be that I just don't understand how, why his principle, which seems to be some attempt, because his principle is even Mr. Dorson's principle of sexual conduct is too narrow for him, why he doesn't reach out and embrace a real Lillian liberalism. And I'm wondering whether he believes that the right to contract at any wage is all which must be also protected by any principle of autonomy.
All right, let's take another question.
Okay, this is directed to Mr. McGinnis.
McGinnis.
This is directed to Mr. McGinnis. You suggested in your opening definition of right to privacy that right to privacy relates to a person's self-definition as interpreted by 5 justices, which is considered fundamental. And I think Professor Chang suggested that self-definition is a problem where one's definition of conflicting definition conflicts with where there's a problem between a person's definition of self, which is understood by that individual, versus conflicting definitions that others hold. Now, if you're suggesting that the court should not act as the mediator, as the final determination where those definitions of self conflict, well, then who then decides what self-definition should be, where there is conflicting definitions of self?
Well, I think if I understand the question, I think I do. The answer, I believe, is generally the legislature, except where the rights that are in some way important to self-definition. And I think that is would have been a very odd formulation for the framers. The Supreme Court now, as you point out quite correctly, uses it. Then it should be decided by the court. But of course, it is the fact that the pursuit of happiness by one individual may, in some sense, offend other individuals. Offend them sometimes concretely, sometimes offend their sense of morality, but offend people in a whole range of ways. And I don't think the Constitution speaks to which activity should be preferred constitutionally unless it comes under the rubric of some specified right. And when it does not, it's for the legislature to decide, and when it does, it's for the court to decide.
All right, any other questions or comments? Step right up.
He's almost finished.
Mr. McGinnis, you said that you don't think Bowers is consistent with the court's previous decisions in the area of privacy. At another moment, you said you draw the line on the other side of Roe v. Wade. But from what you've said, I assume you also think that Griswold was wrongly decided, if you could go back and do it over again. Assuming that's right, what if New York State Legislature tomorrow passed a law similar to that which exists in China, limiting the number of offspring that a family may have? Is that the kind of decision that should be left up to state legislatures, or is there some sort of constitutional principle that would apply in that case?
Well, I think that's a very hard question. And
Good one, though.
I think I'm unsure of the answer to it at the moment. I think I probably would, as I say, I think I probably would say that law should be upheld. But I believe that...
Justice Department isn't working on anything like that now, are they?
But I believe that, and I would believe that our constitutional jurisprudence is distorted when we think up these I think, fanciful hypotheticals and worrying that our fellow citizens are about to pass laws like that. If our fellow citizens are passing laws like that, one of two situations are in effect. Our fellow citizens have gone crazy and that no constitution is going to protect us. Two, I guess I can imagine in 500 years some horrific social situation in which that law seems necessary to reasonable people. And if that were the case, I do not believe that the Supreme Court should strike it down. And that's why I think our jurisprudence shouldn't be tested by those horrific hypotheticals you suggest.
One final question or comment before we wind up this interesting topic. Yes, step forward, please.
I would like to direct this to Professor Dalton. I was somewhat troubled by your definition of privacy in the very beginning of the speeches. You included in the right to be free, the right to be true to one's conscience. And the emphasis in the rest of your definition seemed to be on individual autonomy. And I really have two questions. The first one is very small, and then the second one will bounce off. Is civil disobedience punishable in a democratic society where these rights prevent?
Is civil disobedience punishable in a democratic society?
Where there are such definitions of punishment?
Maybe I should have been a little clearer or more precise. I didn't so much mean the right to be true to one's conscience, but rather the right to be true to oneself definition. That is, if one is a recluse to be a recluse, if one is gay to be gay, if one is. But I wasn't thinking so much in terms of ideas and the right to impose one's ideas on the whole world. So I'm not sure that anything that I said about anything in my definition of privacy speaks to the question of civil disobedience.
Okay, the point I was getting at is that a lot of times when a person makes personal decisions in their own autonomy, very often it's going to run against what the majority in that society has said or what they've interpreted the Constitution to say or any of these other things.
You're absolutely right.
And the second question is, if that is a true definition of privacy, then where do the ultimate values of society come down, where society is going to ultimately have to say, this is right and this is wrong?
Well, you're absolutely right. I'm actually acknowledge, of course, your point, which is that if one were to take seriously my definition of privacy and run with it, and unless you also acknowledge that there were, in some